Judges Matter Research and Advocacy Officer Mbekezeli Benjamin joins us now to discuss this. A very good evening to you, and thank you so much for speaking to us, Mr. Benjamin. Firstly, what is the genesis of this program? Because CASAC had originally complained about it, saying that the work that has been done by the retired justices is effectively the work of sitting justices. It's within their purview.
Yes, good evening, Tepiso. So the background to this program is this. So the Constitution was amended, the 17th Amendment to the Constitution in 2013 meant that the Constitutional Court was now the highest court in all cases. That significantly expanded the workload of the Constitutional Court, because previously a lot of the cases that went to the Constitutional Court ended up only at the Supreme Court of Appeal. But now with the amendment to the Constitution, it meant that all those cases now went directly to the Constitutional Court. So the workload almost tripled overnight, but the justices of the Constitutional Court remained the same. It was still the same 11 since 1994. So the resources available to carry this workload were less than what was required. And so this program was designed to assist with the workload. So what the retired justices would do, they would read some of the new applications and prepare a memo that would go to the Chief Justice, and the Chief Justice will allocate it to a Justice of the Court who will then decide whether to accept the memorandum or to reject it or to amend it in any way that they need to. And the idea was that since the Justices of the Court are the retired justices are experienced and they were previously on the Constitutional Court, they would be able to write a much more sharper and clearer memo, because already the Justices of the Constitutional Court are assisted by law clerks who are recent graduates. So the idea was that you would have additional capacity to assist the justices that would come for free. I think that is also a consideration, that the retired justices would not be paid any additional money because they are already paid by the state as part of their retirement package. So that was the background to this. But of course, CASAC and other organizations, including ourselves, did raise concern because we thought that this comes far too close to the judicial work that should properly be done by the justices of the Constitutional Court.
So in layman's terms, when you say it comes close to the judicial work that should be done, that it is not as administrative as it was put out to be, what is the difference, the salient factors here? Because these are retired justices whom one would imagine that they are still considered members of the judiciary just in terms of their training and their experience, or am I wrong even in that assumption?
No, you are quite correct in that assumption. So these are judicial officers, right? First of all, they are members of the judiciary, or retired members now, and their role would be to first read the case as it comes in, and they will write a memorandum based on their reading of the case. So they will take a particular view of the issues involved in the case. And because they are so senior and so retired, their view is likely to be far more persuasive than a law clerk, so a recent graduate who is under the mentorship of a permanent justice of the court. So what we believe how it becomes judicial work is that reading of a case, that understanding of the issues or framing of the issues is sort of adjudicative in nature. It's not just an administrative work where they just summarizing generally. They already take a view on whether to dismiss a case or to uphold a case or to take it to the hearing of the case. And even though the permanent justice has every option to reject that view or to amend it in any way, by the retired justice already writing and putting out a view, they are likely to be far more persuasive than a law clerk. And so our concern was that that adjudicative role that they are playing is coming very close to a judicial function that should be carried out by the permanent members of the Constitutional Court as required by the Constitution. So we felt that there wasn't a need to bring in senior judges. There could have been another way, because it comes very close to the adjudicative role that is ordinarily played by the permanent justices.
Okay, and again, pardon me to dumb it down, I do also want to bring it to an accessible level. So when you say adjudicative, what exactly do you mean? And I'm thinking against the backdrop of, if we're talking about case flow management, whose responsibility is it? And therefore, would the retired justices not qualify to do this work if, you know, the person who deals with that case flow management is a judge?
Look, it is not simply case flow management in the sense that you're managing the case as it comes in and deciding how the case should proceed further. So maybe let me try to simplify it in a sense that when someone brings an application to the Constitutional Court, obviously they want the Constitutional Court to grant them a hearing, firstly, to take it to a formal hearing where the Constitutional Court will sit and that person's lawyer will argue the case in a full hearing of the Constitutional Court. That is one of the first prizes that people want. And secondly, they want the Constitutional Court to rule on the case, so to make a decision and write a full judgment on it. And basically what the retired justices will be doing in that process will be sort of a gatekeeping function, if I can put it in that way. Because already by reading the case that comes in and determining whether or not someone should go to a hearing, that is already a decision-making or an exercise of a gatekeeping function in a way. And so that is where we believe that gatekeeping function is what can easily be described as adjudicative, because adjudicative means they are taking a decision on the issues. And yes, ultimately that decision might be overruled by a permanent judge of the court, but the mere fact that they've taken the decision, already you've put ideas in the mind of a permanent judge. And because you are so senior, you are retired, you're a former justice of the Constitutional Court, then that idea that you've placed in the mind is far likely to be persuasive and influential. So that is the concern, that you are influencing members of the court, even though you had no intention of doing so. But by virtue of you being a former justice of the court, your opinion weighs heavily on their minds.
Judges Matters Research and Advocacy Officer Mbekezeli Benjamin, thank you very much for your time.